Imagine for a second that you are visiting a friend's house. You're in the kitchen, maybe helping out, whisking some eggs, making coffee. It's early in the morning. Suddenly, there's a bullhorn outside. Law enforcement has surrounded the building. Tear gas canisters crash through the windows, smoke fills the hallway, and the people in the living room immediately grab automatic rifles and unleash a barrage of gunfire.
Wow.
You are just standing there in the kitchen, holding a spatula. Everyone in that house gets arrested for federal conspiracy. The question is, do you go to prison with them?
That is the nightmare scenario.
Mhm.
And in the eyes of the law, the distance between going home and going to a federal penitentiary often comes down to two very specific, often misunderstood concepts. Slight evidence versus mere presence.
And that is exactly what we are unpacking today. We are doing a deep dive into United States v. James, a 1976 decision from the Fifth Circuit Court of Appeals. On the surface, this case reads like an action movie script separatists, an FBI raid, a massive shootout. But underneath all the gunpowder, it's actually one of the most rigorous legal texts we have on the boundaries of conspiracy.
It really is. It forces us to confront a fundamental question. When does a group of individuals become a single legal entity, a conspiracy in the eyes of the law? And more importantly for you, how much or how little do you have to do to be considered part of that conspiracy?
So let's lay out the mission for this deep dive. We aren't just recounting a gunfight. We need to dissect the legal boundaries of conspiracy, specifically how the law infers a common plan when there isn't a signed contract, and we have to nail down that critical distinction between slight evidence of participation and mere presence. Can you frame the analytical roadmap for us? Where are we going today?
Certainly. We have a four-part structure for this. First, we'll define the doctrinal rules of conspiracy under 18 U.S.C. Section 371, and we'll focus specifically on implied agreements. Second, we're going to apply the structured FAIR Act method to United States v. James to test these rules against 7 different defendants.
Wow.
Third, we will distinguish that slight evidence rule, which convicted 6 of them, from the mere presence defense that got 1 of them off. And finally, we'll wrap up with a diagnostic checklist so you can spot these issues instantly.
Perfect. Let's jump right into the doctrinal analysis.
Yeah.
I want to open with the definition of conspiracy itself. You know, a lot of people imagine that smoke-filled room where everyone signs a blood oath.
Right.
So the question is, does a criminal conspiracy require proof of an open covenant openly arrived at? An express, written, or spoken agreement between all the parties?
The general rule is no. No express agreement is needed. The law is pretty pragmatic here. It recognizes that criminals planning to assault federal officers rarely write down their plans.
Right, they don't keep minutes.
Exactly. So the elements of a common purpose and plan may be inferred from what the courts call a development and collocation of circumstances.
Collocation of circumstances. That is a dense phrase.
It is, but it's the key. It just means the jury can look at the situation as a whole, the totality of the circumstances. If a group of people moves in perfect synchronization to commit a crime, the law infers they must have agreed to do it beforehand.
So coordinated action implies a prior agreement.
Precisely. And there's a crucial nuance here. Knowledge of all the details is not required. A defendant doesn't need to know every single part of the plan. They only need to know the essential nature of it.
Okay, that makes sense. So once a conspiracy is established, we know there is a plan. What's the burden of proof to link a specific individual to it?
This brings us to the slight evidence rule. This is black-letter law. Once a common scheme is shown to exist, once the conspiracy is proven to be real, only slight evidence is required to connect the particular defendant to it.
That sounds like a very low bar.
It is. However, there's a very strict limitation. The counter rule is that mere presence at the scene of a crime or mere association with conspirators is insufficient for a conviction. You can't be found guilty just for standing next to the bad guys.
And that distinction, slight evidence versus mere presence, is the absolute heart of today's case. So let's analyze United States v. James. We're going to stick to our strict analysis format here. First, what are the legally dispositive facts?
Here's the essential summary. The scene is Jackson, Mississippi, August 18, 1971. The FBI and local police surrounded a house that was acting as the capital of the Republic of New Africa, or RNA.
The RNA, they were a separatist organization.
Yes, they claimed sovereignty over 5 southern states. The police were there to serve an arrest warrant on a fugitive named Jerry Steiner for murder, along with some misdemeanor warrants for others.
And the RNA wasn't just a political group, correct? The facts show they were militarized.
Heavily. The evidence showed they had established what they called combat wind procedures, and they conducted military drills. Members were trained that when a commander yelled jump, they were to grab weapons and take defensive positions immediately.
So on the morning of the raid, what exactly happened?
At 6:30 a.m., officers used a bullhorn to demand surrender. They gave the occupants 60 seconds. When no one came out, they announced they would deploy tear gas in 15 seconds. They fired the gas, and almost instantly, a heavy barrage of automatic gunfire erupted from the house.
A full-on firefight.
It lasted 20 minutes. One police officer was killed, and 2 others, including an FBI agent, were wounded.
And the aftermath?
7 appellants were arrested. Inside, police found an arsenal, including an AR-180 automatic rifle, Molotov cocktails, and a bomb. And crucially, the fugitive they were looking for, Jerry Steiner, he wasn't even there. He had left the night before.
Okay, those are the facts. So what was the core legal issue?
The precise issue was whether the evidence was sufficient to support convictions for conspiracy to assault federal officers, use firearms, and possess unregistered weapons. Specifically, was there proof of an agreement, and could each individual defendant be connected to it?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements for us.
The court applied the rule for conspiracy sufficiency. This rule has 3 distinct elements.
Okay.
Element 1 is the common plan. The government has to prove an agreement or common design, which, again, can be inferred from concerted action.
Got it.
Element 2 is knowledge. The defendant must know the essential nature of the plan, in this case, that it involved violence against law enforcement.
And the third?
And element 3 is participation. Once the conspiracy is proved, only slight evidence is needed to connect a particular defendant.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply that first element, the common plan?
Let's do the mini IRAC for the common plan. The sub-issue was there actually an agreement to assault officers, or is this just a chaotic, spontaneous reaction to the tear gas?
Right. Was it planned or panic?
Exactly. In applying the facts, the court looked at those combat wind procedures, the military drills, and that coordinated reaction to the jump command. The court noted that the defendants didn't act haphazardly. The fact that they unleashed a coordinated heavy barrage of fire immediately proved a pre-existing plan.
So the conclusion on that element?
The conclusion was that element 1 was met. A common plan existed.
Understood. Now let's look at the second element, knowledge. The defense argued they didn't know the people outside were federal agents. They claimed they couldn't conspire to assault federal officers if they didn't know they were federal. How did the court handle that?
This is the mini IRAC for the knowledge element. The application here focused on the timeline. The court just flatly rejected the defense's claim because the officers announced their identity, specifically FBI, over the bullhorn before the shooting started.
So they were told who was outside?
Yes. The RNA members initiated their combat wind procedures after hearing the federal warrants being announced. So the conclusion was that the jury could easily infer the plan contemplated violence against federal officers. They knew who was at the door.
Okay, now for the most critical part. The third element, participation. We have to look at the defendants individually because this is where that slight evidence versus mere presence battle is fought. Let's start with the leadership. Henry, the president, and James, the interior minister.
All right, let's break down the mini IRAF for Henry and James. Starting with Henry, the application of the rule shows he was the president of the RNA. He supervised the drills, he made public threats, he planned the procedures.
But he wasn't even at the house during the shootout, right?
That's right. He was at a different location on Lynch Street. But the court found he was the mastermind behind the procedures. His agreement was foundational.
I see. And James?
For James, he was the interior minister. He was in charge of the arsenal, he assigned weapons, and he even admitted to firing the automatic AR-180 at, and this is a quote, any white person he could see.
So the conclusion for those two seems pretty clear.
Oh, absolutely. They easily satisfied the slight evidence requirement. The evidence against them was overwhelming.
What about the rank-and-file members, Norman, Austin, Shillingford, and Stalling? How did the court apply the participation element to them?
We can group them together in a mini IRAC about their specific acts of participation. In applying the facts, the court just looked for overt acts, anything they did that furthered the conspiracy.
Okay, like what?
Well, Norman was the vice president, and he admitted to firing a British .303 rifle. Austin was the finance minister. She actually wrote the list of ammunition to be purchased, and she performed guard duty.
So she was handling logistics.
Exactly. Shillingford was the one who went and picked up that ammo, and he fired an M1 rifle. And Stalling helped dig the escape tunnel. He had the women during the fight, and he also did guard duty.
So they all had a specific tactical role.
That's the key. The conclusion is that their specific acts, guard duty, logistics, shooting, digging, all, provided that necessary link. These were tactical acts, not neutral ones.
Finally, let's look at the outlier, Anne Lockhart. How did the court apply the participation element to her?
This is the pivotal mini-IRAC for Lockhart, and it results in a reversal. The sub-rule here is that mere presence or association is not participation.
Okay, so what were the facts about her?
The facts for Lockhart were that she was the wife of the vice president, Norman. She lived in Wisconsin, not Mississippi, and she wasn't even a citizen of the RNA. She'd only arrived 2 days before the shooting.
And what was she doing there?
She bought groceries and cooked meals. She was actually planning to leave that very morning. So in applying the law, the court found there was zero evidence she knew of the specific conspiracy or participated in any of the drills or defense plans.
So cooking meals and being married to a conspirator
Is classified as mere association. Therefore, the conclusion was that the evidence was insufficient. Her conviction was reversed.
And after analyzing all those elements for all 7 defendants, what was the court's final conclusion?
The court affirmed the conspiracy convictions for Henry, Norman, James, Austin, Shillingford, and Stalling. But the court reversed the conviction for Anne Lockhart, all due to insufficient evidence of her participation.
That Lockhart distinction is so subtle but so vital. Mere presence saved her. It really seems to hinge on the nature of the act itself, cooking, versus, say, digging a tunnel.
It does.
Let's make this concrete with a visceral hypothetical to lock it into memory. Let's imagine a scenario we'll call the bank robbery BBQ.
Okay, I am listening. Set the scene for us.
All right. A group of people are in a basement planning a violent bank heist. They're cleaning guns, drawing maps of the bank vault, talking about timing. Person A is sitting at the table sharpening a large hunting knife and just nodding at the map. He doesn't say a word. Person B is the host's cousin who just arrived from out of town. He walks downstairs, sees the guns on the table, realizes these guys are up to no good, but he stays in the kitchen area of the basement making pulled pork sandwiches for everyone because they look hungry. Who's guilty?
This is a classic application of the distinction we just saw in James. Person A is liable under slight evidence.
Why? He didn't say anything.
It doesn't matter. Sharpening the knife while nodding at the plan is an overt act. It connects him to the violent design. It shows his acceptance and preparation. It's a tactical act.
Okay, so he's in. What about the cousin making sandwiches?
Person B is Anne Lockhart. Feeding conspirators is mere association. Being in the basement where the planning is happening is mere presence. Even if person B knows they're bad news or sees the guns, simply cooking food doesn't further the illegal objective of the conspiracy. Person B is not guilty.
So, unless that pulled pork is somehow used to disable the bank guards, he walks free.
Precisely. Domestic or neutral acts don't create conspiracy liability without proof of specific intent to join the criminal plan. The law punishes the agreement to commit the crime, not just keeping bad company.
This brings us to the synthesis. For everyone listening, prepping for an exam, or just trying to spot this in the real world, how do we systemize this?
We can synthesize these rules into a conspiracy diagnostic checklist. If you're analyzing a fact pattern, just follow these 3 steps.
Let's hear them.
Step 1, check for the common plan. Look for a collocation of circumstances. Are the parties acting in concert, like the jump drill in the James case? Don't look for a written contract. Look for coordinated behavior.
If they moved together, they agreed together.
That's it. Step 2, check for knowledge. Does the defendant know the essential nature of the plan? Do they know it involves violence or resistance? Remember, they don't need to know the specific target is an FBI agent named Stringer, just that they're resisting federal authority.
And the final step.
Step 3, apply the connection test. This is where you filter slight evidence against mere presence. If the defendant performs an act that furthers the goal digging a tunnel, buying ammo, holding a gun, they're guilty. The slight evidence rule is met. But if the defendant performs domestic or neutral acts, cooking, sleeping over, just being a spouse, without that specific knowledge or active participation, they're not guilty. That is mere presence.
That is a powerful framework. It really highlights that in conspiracy law, actions speak so much louder than words. The coordinated firing of weapons replaced the need for a signed contract. But being a bystander, even a helpful one who makes dinner, isn't enough.
It connects back to the core principle of criminal law.
Right.
We punish intent and action, not just proximity. You have to be very careful about casting the net so wide that we catch innocent people.
Before we sign off, here's a final provocative thought for you to mull over. We know Anne Lockhart walked free because she only cooked meals. But if Anne Lockhart had handed a single bullet to her husband instead of a sandwich, would she be in prison today?
That changes the entire calculus.
Right. In that hypothetical moment, she moves from domestic support to tactical support. That one motion handing over the ammunition would likely have bridged the gap from mere presence to slight evidence. The line between freedom and a felony is razor thin.
It's a sobering thought. In conspiracy law, the specific nature of the act defines everything.
And that's it for this deep dive. Thanks for listening.